Rector Magnificus, Madam Governor, Excellencies, ladies and gentlemen, Mr. President, dear Danilo, it is my great pleasure to introduce Danilo Türk when he is about to give the 2012 Anna Lindh lecture. Circumstances which we cannot influence made it impossible for him to come to Lund last year. This is not the first time Danilo Türk visits Lund. He has participated in conferences arranged by the Raoul Wallenberg Institute. He has cooperated with the Institute, for instance, when adopting the Lund recommendation on the effective participation of national minorities in public life. It's a long title, but still nowadays a well-known document for the protection of minorities. The first time I met Danilo Türk, he was a well-known professor in international law. He was a human rights lawyer, having a particular interest in economic, social and cultural rights, as well as in minority rights. He has published a wide range of books and articles in the field of international law. In 1986, the UN Commission of Human Rights, now being replaced by the UN Human Rights Council, they appointed Danilo Türk as a special rapporteur on the realization of economic, social and cultural rights. So far, his career followed a rather common line of law professors in human rights. In his report to the UN Commission, he deplored that many states viewed economic, social and cultural rights with suspicion and with a hazy cloud of doubt and treated with an air of triviality. Indicators should be used to measure states' respect of economic and social rights, and he strongly argued for the drafting of an additional protocol to the Covenant, affording individuals and groups the right to submit communications, complaints, alleging non-compliance by state parties. His proposal became a reality only in 2008, when the UN General Assembly adopted a protocol to the Covenant. In 1992, Danilo Türk became the first Slovenian ambassador to the United Nations. This was not a unique step for law professors. There are several examples from other countries when law professors have become ambassadors to the United Nations. While being ambassador to the UN, he was elected a member of a UN treaty body, namely the Human Rights Committee, that is to say, the committee which examines that state parties respect the UN Covenant on civil and political rights. There is nothing unique in such an election. Several academics are members of UN treaty bodies. The next step in his career was more uncommon. He became Assistant Secretary General for Political Affairs to the United Nations. Although he was not the first law professor among the top staff members of the United Nations, this was an obvious sign of Danilo Türk's capacity. However, this is not enough. Between 2007 and 2012, he served as president of Slovenia. So to conclude, Danilo Türk is, to my knowledge, the only law professor having been special rapporteur to the UN, being member of the UN treaty body, ambassador to the United Nations, assistant secretary general in the United Nations, and a head of state. I give you Danilo Türk.
Thank you, Professor Melander. Thank you, dear Joran, for this very lively and interesting introduction, which reminds me that I'm no longer a young person, and therefore I should express some of my views with the necessary hindsight which age takes and brings to the person. But before coming to the substantive part of my statement, I would like to tell you, my friends, how honored I am to be here. Distinguished Governor, Ms. Margareta Paulson, the Governor, Mr. Vice Chancellor, Rector Magnificus, Professor Per Eriksson, Chairman of the Board of Trustees of Raoul Wallenberg Institute, Lenar Svensetar, Ambassador Hans Korell, friend, former Chairman of the Board of Trustees, Director Maria Tuma, Ambassador of Slovenia, Ambassador Bogdan Benko, distinguished professors and dear students. It is a great honor for anybody, for somebody like me in particular, to be given the opportunity to deliver the Anna Lindh Memorial Lecture here in this solemn and elegant environment of Aula Magna of the University at Lund, at the invitation of the Raoul Wallenberg Institute. I'm saying this because all of us who knew Anna Lindh have greatly admired her political acumen, her honesty, her commitment to humanity, and above all, her warm personality. I fondly remember many meetings at the headquarters of the United Nations in New York, where Anna Lindh participated tirelessly and with unique energy. Whether she spoke about development, human rights, environment, or the situation in the Middle East, she was always convincing and very impressive. In all those discussions, she expressed a strong human commitment, and her contributions greatly energized all political debates. She was giving us all a sense of importance of our work as diplomats, international civil servants, or experts. Her message to all of us, her appeal to bring a strong human touch to international affairs, continues now to resonate and to inspire. And obviously it's natural that an immediate thought about the political legacy of Anna Lindh invites a reflection on human rights, on action on the field of human rights. What has been the road traveled so far? Where does the world stand today? Has the era, sometimes described as the age of human rights, that is the period between mid-1970s and the end of Cold War at the end of 1980s, left durable achievements? And what should be our priorities for the future? Questions like this seem obvious, an obvious choice of the theme of a lecture in the memory of Anna Lindh. In addition, I would like to say that I have a deep personal attachment to all these issues. I became active in human rights work many years ago. As a student, about 40 years ago actually, in 1972, through correspondence with Amnesty International, which was at that time still a relatively new organization concerned about human rights of prisoners of conscience in many countries of the world, including in former Yugoslavia. Later, I became active in the intergovernmental and non-governmental work, and through non-governmental channel also the United Nations. So when I was preparing this lecture, I was remembering a day in February 1975 when I traveled as a young NGO activist, among many other young NGO activists, to Geneva to take part at the NGO work related to the UN Commission on Human Rights, which was in session at that time. And I still vividly remember, physically remember, the long windowless corridor from Porte Numero 6 in the old palace of the Société des Nations to Bâtiment E, the ultra-modern UN building, and several glass doors which opened automatically as I approached them. This gave the place an awesome image, reminiscent of scenes from James Bond movies. And I understood, as a young student at that time, that something very important is awaiting me at the end of that corridor. And finally, I reached the new UN building and the conference room 17, where the Commission was holding its meetings. The place was lively. It looked more like an active international bazaar than a diplomatic conference. NGO representatives and academics mixed with a variety of conservatively dressed diplomats in a host of intensive discussions in the conference room itself and in the adjacent Serpent Bar. The atmosphere was filled with excitement. The Commission had just decided to appoint a special rapporteur to study violations of human rights in Chile. And the ensuing adjournment of the meeting produced a situation both inspiring and chaotic. And of course, this is a typical situation for human rights, inspiring and chaotic. The NGO world saw that decision as an important step forward. the international attention to violations of human rights was strengthened very significantly. The UN has started its action to counter violations of human rights in places other than South Africa or Middle East, the hitherto main geographical areas of concern. For the NGOs, it was only a question of time when the international attention will turn to other Latin American, at that time military dictatorships, and to the countries of Eastern Europe under the communist rule. The expectations of the international NGO community proved later on to be well-founded. In the same year, in 1975, the Helsinki Final Act on Security and Cooperation in Europe included legally modest but politically very powerful provisions on human rights. The new American administration, which was elected in 1976, put human rights at the center of its foreign policy in Europe. In the following year, a group of European intellectuals signed a document titled Charter 77, an appeal for implementation of human rights provisions of the Helsinki Final Act. The years that followed changed the political landscape of Europe and the world. They proved the transformational power of human rights, and the age of human rights has dawned. The developments of late 1970s and 1980s have been described as the age of human rights. This is fully justified given the magnitude of social and political change in large parts of the world and the fact that much, if not most, of that change was inspired by human rights and often led by human rights activists. Human rights became a powerful and internationally highly relevant political idea. Political actors who strived for change had to make use of human rights as a tool of political battle if they wished to succeed. Obviously, not all the slogans expressed at that time were meant seriously, and as it often happened in history, positive mobilizing ideas were sometimes abandoned after the desired political change had been achieved. Nevertheless, the power of human rights was strongly reconfirmed. The wave of change has had important repercussions in the international institutions of the time, including the United Nations, where the activities in the field of human rights gained new dynamism. For the UN, of course, human rights had been one of its central ideas from the beginning. It is worth recalling that the UN Charter begins with the words, "We the peoples," and not, as was the case with the Covenant of the League of Nations, UN's predecessor, with a solemn reference to the high contracting parties. The Universal Declaration of Human Rights, adopted in 1948, represented a stellar moment in the organization's history. It articulated with unprecedented moral authority and with far-reaching normative effects a set of basic human rights which continue to be, as stated in the Declaration, a common standard of achievement for all peoples and all nations. In addition, and I would like to emphasize this very strongly, the Universal Declaration contains an article, Article 28, which provides, "Everyone is entitled to a social and international order in which the rights and freedoms set forth in this declaration can be fully realized." This provision contains two messages of fundamental importance for all subsequent work in the field of human rights. First, the idea of full realization. It does not suffice to recognize or only formally enact human rights. The objective of their full realization, which requires constant action, sometimes in the form of legally defined protection and often in other ways, through the strengthening of awareness or through assistance to those whose rights are violated or ignored, is put on the agenda. And second, the Universal Declaration called for development of a social and international order which would enable full realization of human rights. This is a far-reaching objective, a tall order indeed, which already at the first glance implies a multitude of tasks, political, legal, economic, and social. It also succinctly explains what a good society is. It is a society with a social order in which human rights can be fully realized. And today, we still admire the level of optimism and ambition of the authors of the Universal Declaration of Human Rights. And this is why I'm putting Article 28 of that declaration in the center of my thought and in the center of this lecture. Looking at Article 28 in retrospect, it is also easier to understand the importance of building legal structures for the needed social and international order, the importance of political and legal legislative imagination, and formulation of institutional instruments specifically designed to bring actual reality closer to that very lofty and very important objective. In retrospect, again, the construction of normative, institutional, and practical elements had to overcome a variety of difficult situations. UN activities following the adoption of the Universal Declaration of Human Rights were seriously constrained by the Cold War. However, that obstacle did not completely paralyze the human rights segment of the organization. Much useful legislative work was done in the 1950s and 1960s. That work included 2 international covenants of human rights, which were adopted in 1966 and entered into force 10 years later, in 1976, at the dawn of the age of human rights. The first optional protocol to the Covenant on Civil and Political Rights provided for individual complaints and over time gave rise to a significant body of human rights jurisprudence. There were other international treaties designed to prevent and combat racial discrimination, to foster equality of women and men, to protect the rights of the child and others. A number of the UN declarations containing provisions of soft law developed the normative landscape further. All that represented a significant legal and political basis for human rights activities which followed. Now, many among these activities for promotion and protection of human rights were based on patterns of legally defined implementation of international standards, like state reporting, individual complaints, general comments guiding the interpretation of human rights law, new standard setting, and the like. But some of the activities which happened in the period which I describe as the age of human rights were quite innovative and imaginative. And let me mention just a few. The Human Rights established a Commission of Working Group on Enforced and Involuntary Disappearances, which established a search system to trace missing persons in every corner of the globe and requested the relevant governments to cooperate within the United Nations to find these people. The abhorrent practice of disappearances, which had been among the most widespread violations of human rights, in particular in some Latin American countries, was countered by an organized international action in which the UN played a significant role. Reporting about the introduction of the state of emergency in different countries in the world was another innovation that provided a welcome insight into situations in which human rights became threatened as a result of emergency laws and regulations. This facilitated an early attention to situations which were particularly threatening human rights. A number of country-specific rapporteurs was appointed by the Commission on Human Rights. They focused on violations of human rights in specific countries and provided a credible basis of information and analysis that followed the international action to crystallize around those findings. The recent changes in Myanmar, Burma, remind us of the contribution made to this positive development by the highly committed special rapporteurs of the situation on human rights in that country. The international efforts persisted for almost 3 decades and have contributed significantly to the recent and encouraging changes. However, it should be mentioned in passing that progress in Myanmar achieved so far is neither complete nor irreversible, and that international attention should continue. Now, thematic rapporteurs and working groups dealing with such issues as protection of the independence of the judiciary, the abolition of practices of administrative detention, the application of minimum standard rules on treatment of prisoners, the situation of conscientious objectors to military service, all these thematic discussions help to improve the respect for and implementation of human rights standards. Some among thematic rapporteurs, like the ones addressing the horrors of torture and arbitrary executions, have raised critically important issues of human rights in the most sensitive political situations and made them subject of systematic international concern. Obviously, not all human rights activities have been meant to address violations. Some were designed to deal with age-old injustices, which require major change in policies. The UN work for indigenous people indigenous peoples is a case in point. Still others, like the activities on the right to development, try to break new paths in the evolution of the doctrine and policy of human rights and to produce new balance between civil and political rights on the one hand and economic, social and cultural rights on the other. The age of human rights, which has produced all that innovation, has culminated in the 1980s, first with the demise of military governments in Latin America and ultimately with the collapse of communism in the Soviet Union and Eastern Europe. In 1988, a year before the fall of the Berlin Wall, 40th anniversary of the Universal Declaration of Human Rights was already celebrated in the spirit of victory of human rights and their transformational power. Thus, the age of human rights reached its summit, and new visions were called for. In the wake of their victories, the international human rights NGOs launched a new guiding principle, which read, "There should be no impunity." No impunity for human rights violations. This strategy was initially, in the 1980s, connected with the demise of dictatorships in Latin America. A resounding no to impunity for the perpetrators of human rights violations seemed logical and indeed necessary answer offered by the international human rights community. It is understandable that the very fact of ending violations of human rights raises the question of consequences. Should the victims be compensated, and if so, how? Should all the perpetrators be punished, and what is to be done in case of massive violations involved a very large number of victims and proportionately large number of perpetrators of human rights violations? How does one achieve reconciliation in societies deeply affected by human rights violations? The key answer was believed to have been found in the slogan, "No to impunity," and, of course, in the underlying idea of retributive justice. However, the consequences of retributive no to impunity approach were initially less than fully understood. The complexities of this approach became apparent gradually. It takes a long period of time to truly redress the injustices resulting from massive and systematic violations of human rights. At the political level, it is not always clear what should come first, justice or reconciliation, or how to combine the two. In abstract, one could always claim that justice is fundamental for reconciliation. But in most situations, both have to go in parallel and require careful determination of immediate, short-term priorities, in particular, the need to prevent new violations in such situations. Retributive justice has to be accompanied by activities of restorative justice, with activities aiming at restoration or creation of an atmosphere of trust and confidence in justice and its effectiveness for all members of society, a daunting task. The questions which have arisen in the wake of the victory of the age of human rights are still with us, and there are no easy answers. Moreover, in one of the many bitter ironies of history, new and unexpectedly dramatic challenges to human rights arose in the aftermath of the Cold War, in the period when feeling of victory of human rights was still fresh. Atrocities committed in the Balkans in the first half of the 1990s, genocide in Rwanda, massive violations of human rights and humanitarian law in West Africa in the latter part of the 1990s, and in the Democratic Republic of Congo, and in the Sudan later on, have posed new challenges to the international community and to human rights world in general. How does one ensure that there is no impunity in this kind of situations? The challenge of how to effectively address violations, the depth and magnitude of which have been unimaginable in the age of human rights which just ended. This was compounded by the lack of political will and ability of the international community to agree on meaningful responses to man-made humanitarian disasters and the massive human rights violations which marked the ending of the 20th century. A partial answer to this challenge was found in the creation of a number of international or mixed international domestic tribunals that were established to try the principal perpetrators of massive violations of human rights law in the area of former Yugoslavia, Rwanda, Sierra Leone, and in Cambodia. Later on, the International Criminal Court was established, which represented a very large step towards the building of international architecture for global justice and protection of human rights. And I'm very pleased, I have to say this on this solemn occasion, I'm very pleased to see Hans Corell with us tonight. His contribution to the creation of the International Criminal Court and to development of various international and mixed tribunals has been truly historic. The international courts and tribunals have already accomplished much and need to be supported politically, financially, through NGO advocacy, and very important, through the media. Victims of massive violations of human rights committed in contemporary armed conflicts need to know that there is hope that justice will be done, if only partially and with long delays. Now, the legal and institutional developments, one unable to prevent or at least contain massive violations of human rights in the past 2 decades, have rejected impunity, and that's important. Rejected impunity and have created institutions of justice which can be realistically expected to have a preventive effect now and in the future. They have become a solid part of the architecture called for Article 28 of the Universal Declaration of Human Rights. Kofi Annan, former UN Secretary General who has contributed decisively to the strengthening of international justice and the rule of law, described this development succinctly, and I quote, "In the face of war crimes, crimes against humanity and genocide, the default position of the international community is now accountability and not impunity." End of quotation. Now, this is an important achievement. Strengthening of accountability for human rights violations, whether committed in armed conflicts or in the time of peace, will remain a vital priority for human rights. Justice and reconciliation, among the key elements of human rights agenda for the 21st century. So is the need to strengthen protection of civil and political rights in all parts of the world, to ensure that there is no sliding back and that there is progress where progress needs to take place. An important source of encouragement regarding the progress of human rights in the beginning of the 21st century lies in the institutional structures which have been built so far. The UN High Commissioner for Human Rights, established in 1994, strengthened the UN action. The Human Rights Council, which replaced the politically exhausted Human Rights Commission in 2005, brought new energy and started the practice of universal periodic review of human rights situations in all UN member states. Regional human rights mechanisms, in particular those of the Council of Europe, were strengthened over the past decades, and their regional scope has been broadened. And all these are important achievements. However, the objectives of Article 28 of the Universal Declaration still appear distant. An impassioned review of the entire human rights landscape today might even suggest that while there have been significant improvements, the times are uncertain now, perhaps more uncertain than they were 40 years ago. And let me illustrate what makes me think that way. Economic growth of the past decades, where it has taken place, has not resulted in a proportionate improvement for human rights. The economic and social situations in most countries in Global South remain disturbing. Furthermore, the economic recession of the past years has created new forms of poverty, exclusion and inequality in many developed countries of the North. Economic inequality has become a major global problem, described as a problem of wealth and income extremes. According to a recent report by Oxfam, a well-known and well-respected British humanitarian organization, the richest 1% of the world's population has increased its income by 60% in the last 20 years, creating a situation of extreme wealth that Oxfam defines as economically inefficient, politically corrosive, and socially divisive. In other words, a situation of inequality is created which is likely to have negative repercussions of human rights in general. And this is not only the thinking of humanitarian organizations or human rights activists. World Economic Forum, an elite organization of global business, has listed extreme income disparities as one of the major threats to global peace and security, to global prosperity in the year 2013. Moreover, inequality of women in many parts of the world and precarious situation of other vulnerable segments of society and social groups add to the feeling of uncertainty. Specific challenges of human rights exist in multi-ethnic societies. Multiculturalism, now recognized as a fact in many parts of the world, has made the question of balance between, on the one hand, individuals' human rights, and on the other hand, the respect for collective identities, more important than ever before. Policy making which should satisfactorily define this balance between individuals' human rights and collective identities is often lagging behind. So another element of uncertainty. Terrorism continues to pose serious threats to human rights and calls for effective measures of counterterrorism. However, the measures of counterterrorism require very careful scrutiny in order to avoid the trap of violations of human rights committed in the name of security. Now, these are examples. These are a few examples of human rights questions today. They illustrate the thought that we actually now live in an era of uncertainty. There have been gains, there have been achievements of the past, but the situation remains uncertain. Obviously, contextualization of human rights issues and setting of policy priorities is a continuous process. This has always been so. And ideas about future human rights action need to be proposed and tested continuously. And this is why I wish to propose tonight for your reflection two suggestions which should be, in my opinion, among the key priorities for the future. And let me, in the spirit of my early human rights activism, try to put them in the form of slogans. The first slogan is this: economic and social rights are human rights. And the explanation that in the globalized world of today, these rights must be recognized and treated as human rights. The second slogan: we need a global rule of law report, an instrument of strengthening the needed protection of human rights. Now, let me elaborate on these two specific suggestions and two slogans briefly. Economic and social rights were included in the International Bill of Rights at the earliest stage in the Universal Declaration in 1948. Obviously, the nature of their realization has depended on the general level of development of a given society, on the availability of the necessary resources, and on the political orientation of the state concerned. However, with time, certain basic principles related to the realization of these rights gained in authority. The most important agent in this context has been the International Covenant on Economic, Social and Cultural Rights and its expert committee, which by now the covenant includes more than 160 state parties, and which emphasized the corresponding obligations of states, both obligations of conduct and obligations of result. States are required to take steps towards full realization of economic and social rights. Such steps should be deliberate, concrete, and targeted as clearly as possible towards meeting the obligations recognized in the covenant. Furthermore, states have to ensure that these rights be exercised without discrimination. On the other hand, any deliberately retrogressive measures, and we have to recognize retrogressive measures do take place, sometimes as a result of economic crisis that we are witnessing, in that regard would require the most careful consideration and would need to be fully justified by reference to the totality of rights provided for in the covenant and in the context of the full use of maximum available resources. These are the words which the Committee on Economic, Social and Cultural Rights used in their general comment on the nature of state obligations in that regard back in 1990. They are very important in my opinion. They have to be revisited and have to be given a renewed energy. Now, these normative requirements are of importance today at the time of retrogressive measures, which are often considered as a matter of economic necessity. At present, most developed countries give an absolute priority to financial considerations, often at the expense of economic and social rights. The European Union's social model is under stress. While the situation in developed countries appears to be somewhat unclear and sometimes deteriorating, the situation in the developing world remains deeply disturbing. Economic and social improvements of the past decades have been uneven. While millions of people have been lifted from poverty in some countries, improvement has remained elusive to most. Globalization was not lifting all boats, as the enthusiasts of globalization once believed. Benefits of economic growth have remained elusive for many, while the systematic problems of kleptocracy, corruption, and abuse of economic power deepened the deprivation, affecting above all the realization of economic, social, and cultural rights and adding to social and political instability. The uprising in the Arab world, which started 2 years ago, and which is continuing in an unpredictable direction, is an important indicator of more general problem. Economic and social situations do matter to human rights in a variety of ways. The Arab uprising has been motivated at least as much by the quest for work and decent standards of living, both of these values being enshrined in the Universal Declaration of Human Rights, as by the desire to put an end to arbitrary arrest, torture, and to get rid of ossified and corrupt dictatorship. Both of these objectives were expressed in the quest for change. Economic and social rights have been put on the human rights agenda forcefully by the people concerned themselves. Now, and all this has important implications for the international community as a whole. Economic and social improvement is not only one of many desiderata, it is an important human priority and a matter of human rights. States should devise appropriate policy responses, and international institutions should help. It is preferable to address these issues now than let them degenerate into further political upheaval and new forms of authoritarian rule. Let me repeat, economic and social rights are human rights and have to be treated as such. Now, my second proposal for reflection relates to the need to strengthen the rule of law. Human rights not only define the fate of the individual, they also determine the quality of the state in which the individual lives. The state has a variety of duties vis-à-vis the individual. Some of them require the state to refrain from interfering in the individual's freedom as defined by standards of human rights. Some other duties constitute the responsibility of the state to protect the individual against the abuse of human rights, whether committed by state agents or by others. It is precisely at this point where the attention of human rights activists must be placed today. The forms of abuse of rights of individuals evolve, and so does the role of state as a protector of human rights. The state must ensure the rule of law. It is necessary to ensure the rule of law constantly, and that this objective is upheld and new challenges that emerge are met in timely and effective manner. Cultivation of the rule of law is the order of the day, and it is a continuous process that requires constant vigilance and action. Obviously, this must take primarily at the national level, and within those organizations such as the Council of Europe, which place rule of law among their principal objectives. But at the level of the UN, the situation is also important, however, it is more complex. The UN has made significant efforts to strengthen the rule of law at the national and international levels. According to the official UN website, over 40 UN programs, funds, agencies, and other entities are engaged in a wide variety of rule of law programs in more than 110 countries nowadays. As a fundamental principle of the UN Charter architecture, the principle of rule of law has special importance for the discharge of responsibilities of the UN principal organs. According to the recent analysis by the Security Council report, an independent research organization based in New York, a general understanding about the importance of accountability as a tool in the discharging of Security Council's primary responsibility for the maintenance of international peace and security already exists. However, it still needs to be fully internalized in the Security Council and its members and in its action. The General Assembly, on the other hand, has taken up the principle of the rule of law on several occasions in the past decade, and in September 2012, in last year, adopted a declaration on the rule of law at the national and international levels. And all these efforts of the UN needs to be praised, and even more importantly, they need to be supported. At the same time, we have to be cognizant of the global picture, which offers some disturbing news. Studies done by the World Bank and the World Economic Forum indicate certain weakening of states, including a number of developed countries, in areas such as regulatory quality, government effectiveness, accountability, and most disturbing, in less than satisfactory effectiveness in fighting corruption. At the first glance, this seems that such features of weakening of state do not relate to human rights, that they just relate to weakening authority of the state, which we have seen for decades now. However, shortcomings in these areas weaken the position of the individual in a society and eventually affect his or her human rights. For example, the right to an effective legal remedy, or the right to take part in the conduct of public affairs in a meaningful way. If extended over a period of time, they also reduce countries' competitiveness and weaken the economic base for the realization of economic and social rights, such as the right to work and the right to social security. The rule of law is critical for the full realization of human rights. There is nothing particularly new in this understanding. What is new is the realization that today human rights require a much higher quality of rule of law than currently available. This is why the efforts of the Council of Europe, the United Nations General Assembly, and the UN Secretary General and research institutes are so important and deserve full support. The recently published Guide to Politicians on the Issues of the Rule of Law, prepared by Raoul Wallenberg Institute and the Hague Institute for the Internationalization of Law, this is a welcome innovation which merits wider discussion and action within states. It may look rather embryonic at this stage, but it has a huge potential of developing a discussion that can lead to meaningful improvement. So let me conclude with a specific suggestion relating to the tools to promote the principle of the rule of law that need to be developed at the level of the United Nations. I hope that one day, in not too distant future, the ongoing UN work will enable the production of an annual United Nations report, a report which I would call a global rule of law report, similar to the existing human development report. A global rule of law report could analyze progress made in the United Nations member states in areas such as regulatory quality, functioning of the judiciary, accountability of public administration, and the effectiveness of the institutions fighting corruption. And above all, it would provide an opportunity to review progress over a period of time. Much information already exists, and much work has been done already. The question now is whether there is sufficient political will and organizational capacity to bring the existing information into a single report. And this is necessary to make a global report on the rule of law possible. Now, this final proposal, this question brings me back to Article 28 of the Universal Declaration of Human Rights, to the entitlement of every individual to an order in which human rights can be fully realized. As I said before, this is a tall order. Strong efforts are needed to make real progress towards this objective. Both energy and technical sophistication are needed today. Perhaps more energy and more technical sophistication than we had in the years that are called the age of human rights in late 70s and 80s. And as usual, the key requirement to this is political will. One could say that a global rule of law report may not be possible at this stage. There may be non-governmental initiatives in that direction, but not a UN document, a UN action in that regard. Well, people today expect bold steps forward. Their expectations regarding the action of states and the United Nations are high. Decision makers have to perform better, and technical tools such as UN reports can be of considerable help to them.
So let us develop this new idea. Let us develop many new ideas. Let us be ambitious in our thinking. And let us turn the era of uncertainty into a new age of human rights. Thank you.